Good morning. I am Dixie Newnham, and I am happy to have you all here today. I am with Newnham Land, LLP here in Wimberley, and I practice in the areas of estate planning as well as some business work. And today we are going to be talking about beneficiary designations and ownership rights and how they affect your estate. I am recording this, as I mentioned, and it should be available on the website for the library after this on their YouTube channel. And so if you want to take another look at it once we're done, please feel free to do that. Also recognize that this is just general educational things that we're providing here. This is not specific to any particular individual. And if you have any questions about your specific circumstances, we recommend that you consult a estate planning attorney. There are plenty in the state of Texas that you can talk to, and most of us are really happy to talk to people about this because we feel pretty passionately about it. So again, this is just for educational purposes, and you should be able to find it on the library's website after we are done here today. Real quick, I'm going to do an overview of what we have covered before under wills and trusts, really short, just so if you have some questions, you're thinking, hey, I would like some more information, you kind of know which video to go back and look at on the YouTube channel for the library. So we covered wills in our first section, and we covered basically some do's and don't do's, basic provisions, dangers of doing it yourself or outdated wills, and then why really everyone needs a will in some way, shape, or form. And then the second session that we had, we covered trusts, and people tend to think that trusts are just for people who are wealthy or have a lot of assets. But we covered why you might want one beyond that, such as to help with aging, if you have minors, disabled, or spendthrifts you're trying to leave things to, unknown or unliked spouses, avoiding probate, and out-of-state property. So if you have any questions on what a trust is or when you might want one, you might want to look back at that series. So that's what we covered there. So what are we going to cover today? Today is something that affects both wills and trusts, and that is how property is owned and beneficiary designations. So these two things can affect what ultimately happens under your will or under your trust. So we're going to talk about them separately, and I'll start with the joint ownership portion of this. And generally, there are two types of joint ownership out there. Different states can use different terms for these, but generally they are called tenancy in common or joint tenancies with rights of survivorship. And we'll cover today what both of those mean and the impact of that on any estate plan that you have. And then we'll also cover the types of assets that this usually applies to. And so usually we're talking about real property, cars, and accounts like bank accounts or investment accounts. But we'll talk about that a little bit more as well. So let's, before we jump in, I just want to get this caveat out there because Texas is a community property state. Community property does have an effect on all of this. And so one of the more common things that I see is people come to my office and say, well, both of our names are on this bank account, or both of our names are on this piece of property, and therefore this piece of property is community property. And I just want to make the point here that the mere fact that both of your names are on a piece of property does not make it community property. So what does that mean? Whether something is or is not community property is really determined by the inception of title. And what that means is when the property was acquired and also how it was acquired. So for something to be community property, it has to be acquired during the marriage. And the exception to that is gifts. For it to be separate property, it has to be acquired before the marriage, and separate property also includes gifts. So if you have a gift that you received during the marriage, let's say you were lucky enough to receive some money from mom or dad as an inheritance. And you take that money and you put it into a joint account with you and your spouse. Just by putting it in the joint account, it does not necessarily make it community property. So we're not going to go any farther into that than this, because this discussion, when you start adding in types of ownership with community versus separate property, typically makes people feel like that cat at the bottom of the page, like, whoa, what are you talking about? And it is very factually specific to your specific circumstance. I just want to throw that out there because particularly in Texas, you can't just throw away the community property concept when you're talking about estate planning, but it is too much to cover today. So just be aware that that's out there. And when you're doing your estate planning, it's something that you need to talk about and address. So, but let's talk about ownership, not concerning ourselves with community property at the moment. So let's start with the first kind, which is sometimes called tenants in common or common ownership. This is when you have two people that own something. So here you have a picture of me with a picture of my spouse. And let's say that we owned a piece of land as tenants in common. That means we both are on the deed for that land. So what would happen if I died? If I was to predecease my spouse and we were tenants in common in a piece of land, my interest in that piece of land would flow down to my estate. So what that means is it would be handled by the will. Whatever will I left is who would end up, whoever I left it to in that will would be who ended up with it. So if you are tenants in common with your spouse on a piece of property, that would mean after the first of you that dies, your spouse would continue to have a half interest, and then your half interest would go according to your will or estate plan, or if you don't have a will or estate plan, according to the laws of intestacy. So it may go to someone other than your husband, or it may go to your husband if you leave it to them, but it's going to flow through your estate. So that's tenants in common or common ownership. And let me just also make this point here. Although these examples will include me and my husband, it could be any two people. So most often you see this with spouses or with parent and child, but occasionally you do see business partners that own something tenants in common, or brothers and sisters, siblings. So it doesn't have to be a husband and wife, although that is the example I'm using today. So let's talk about the second kind, which is an ownership with rights of survivorship. Sometimes this is called joint tenancy. In Texas, really the term right of survivorship is what drives this type of ownership. So that's how we're going to term it today when we're talking about it. But just know that joint tenancy is also another term that is often used in this regard. And so like tenants in common, two or more people own something. So again, let's say me and my husband own a piece of land. But this time, instead of owning it as tenants in common, we own it with rights of survivorship. Well, what does that mean? So let's say again that I predeceased my husband. Where would my interest go? Because we have what's called rights of survivorship this time, my interest would go to my husband. So that means that after my passing, my interest would automatically go to him. He would own 100%. So tenants in common, he would have owned just 50% at my passing. As rights of survivorship, he gets the whole 100%. So how do you know if you own something as tenants in common or with rights of survivorship? Your default is tenants in common. So if you own something and you do not have specific language or specific written agreement that says you own it with rights of survivorship, then your default is tenants in common. So simply both being on a deed or bank account is not enough. You have to have this specific language that you intend to be owners with joint tenancy with rights of survivorship. And in Texas, you actually have to have a separate written agreement as to rights of survivorship. And that partly has to do with the community property aspect of Texas. So let's talk a little bit about the assets that this usually applies to. The most common one you probably see is real property. So what's covered by real property? That can be land, houses, buildings, even timeshares can have this aspect to them. And so depending on which state you're in, depends on how common this is. So in Texas, tenants in common is actually your most common way for a husband and wife or anyone to own a piece of property. In Texas, there are very few properties that are actually owned joint tenants with right of survivorship. Now, in different states, it can be different. So, for example, in Colorado, another state that I'm licensed in, you often see spouses owning property as joint tenants with rights of survivorship. So it's important that you understand that if you've lived in another state before and you thought, oh, well, I thought if we were husband and wife, we own this piece of property, I'd automatically get it all upon my husband's death. And then you move to, that may have been true in that state if you had it joint tenants with rights of survivorship, but then you move to Texas and most of the time it is tenants in common. So that's a common misconception that I see is people who own property here in Texas think that if their spouse dies, they automatically get the remainder of the property, which isn't necessarily true because they're holding it as tenants in common. The other, probably the second most common place where you see joint ownership is with accounts. So that is bank accounts, investment accounts, those anywhere where you are holding money, stocks, bonds. Now, I will tell you there's an exception to this, and that is retirement accounts. So IRAs, 401ks, those are only owned by one individual ever. So when I'm talking about accounts that can have more than one owner on them, I'm talking bank accounts, investment accounts, anything that is not a IRA, 401k, or other tax preferred retirement account. So you do often see this with bank accounts. And oftentimes banks will encourage people who are joint owners to become joint owners with right of survivorship. They'll just kind of put that paperwork right in there when you are signing up. And something you need to be aware of. So we'll walk through a couple examples here in a second of what happens when you are a joint owner with right of survivorship on a bank account and how that can trip you up. But banks tend to like that because if someone dies, it makes it very easy on them to continue to have an owner on that account and administrate it. But you need to be aware of that. And how would you tell if you had a bank account that two people were on, whether you were joint tenants with right of survivorship or tenants in common? You would look at your paperwork. Your paperwork from the bank will indicate clearly which you are. Your paperwork from when you opened the bank account. Let me clean that up a little bit. In Texas, you also can own automobiles with a right of survivorship. So it is not uncommon for, again, spouses to own their cars together. But typically you own them as tenants in common unless you have done one of these agreements from the Texas Department of Motor Vehicles that I'm showing here on the screen. So you can actually file one of these with the Texas Department of Motor Vehicles and change your ownership interest from one of tenants in common to one of rights of survivorship. Why might you want to do that? It can help you with probate on the back end. It makes it easier for the spouse who is remaining to just take ownership of the car without really having to do anything else. So they are actually a very helpful thing to have, in particular for cars. But let's talk about some of the things that might trip you up. So you may be thinking to yourself, okay, if I am on an account that's ROS, a right of survivorship, with my spouse, and I have a will that says something else, which would win? So ultimately, if you have a right of survivorship with someone on an account, a piece of land, a car, and you have a will, and your will is different than who owns that with you, your right of survivorship will trump. So those assets that you co-own with someone with a right of survivorship pass outside the will, meaning whatever the will says doesn't apply to rights of survivorship. Okay, so let's walk through an example so you can see what that looks like. So let's take me and my husband again, and let's say that we have gone and we have gotten one of these motor vehicle forms for our cars, and we have made sure that we are both joint owners with right of survivorship on these vehicles. And so then, being the proud and concerned parent I am of our children, I make a will, but I decide I don't want to leave the car to my husband. I want to leave my interest in the car to my kids, because one day, one of them, unfortunately very soon, that's an old picture, is going to be driving and may need a car. So let's say, unfortunately, I predeceased my husband and children. Who ultimately takes the car? Is it my husband, who has the right of survivorship, or is it my kids that I left the car to under the will? It's my husband. So it doesn't matter that I have something different in my will as to the car. My interest will go 100% to my husband, which may not be a bad thing, right? That may be something that you want. It can make it super easy for spouses, but it is something you need to be aware of, because that may not be the result that you want. And in my case, if I've done a will that said something different, that probably wasn't the result that I wanted. So let's take another example. This time, let's take a bank account. Let's say I've passed. And so my husband has decided that he wants to put our son on the bank account with him. My son is now grown up. My husband's aging. He no longer wants to handle his finances on his own. He would like a little bit of help. And so he says, I'm going to put our son on this bank account with me, and I'm going to do it with rights of survivorship. What happens? So my husband then goes along and he does a will. Being a good father, he wants to leave everything, including this bank account, to our two kids in equal shares, 50-50. So there's our son, there's our daughter. My husband makes this will saying everything to them both 50-50. My husband passes. What happens to that bank account? It ends up going to our son 100%. So by having the son on the bank account with joint right of survivorship, my husband effectively writes our daughter off of that bank account or receiving anything under that bank account after my husband dies. And so I actually have seen this play out with some regularity. And typically there are kind of three things that happen. One is the son says, you know what, I know what dad's wishes were and it wasn't this, so I'm going to give the 50% to my sister. That's the best kind of case scenario it happens. The second scenario that I see is son goes, I know what dad wanted. I also know that my sister doesn't spend money the way that I think she should spend money. And so I'll give it to her, but I'm going to put some strings attached to it. So instantly a situation has been created where one sibling can exert power over the other, even though that may not have been the intent of my husband in saying this all up. You know, if you remember, the intent of my husband was to have some help with his bank account, not necessarily leave everything to our son. And then the third thing is son could just go, yeah, my sister's never been nice to me. She was mean to me when I was a kid. I'm not going to give her anything. And so here's the issue with that. Some people will say to me, well, I don't really care. I'll be gone. They can fight over it if they want. Unfortunately, too many people equate money with love and gifts with love. And so what I see is, unfortunately, in that third scenario, if son just holds on to everything, usually that leaves daughter, whoever was accidentally written out, feeling pretty crappy about their relationship with dad or whoever died. And at that point, dad, whoever died, can't fix it. They can't tell daughter, that wasn't what I intended. I intended something else. And so it's something to be careful of and cognizant of, because once you're gone, you can't undo or explain those feelings. Like I said, unfortunately, too many times I think people equate what they're left with in terms of money and possessions with, you know, how much their parents loved them. So something to be very careful about if you're going to start putting kids on bank accounts with you. So let's say my husband has watched this and he says, well, I'm definitely not putting Thomas on with a right of survivorship. I'm going to put him on as a tenant in common. All right. So he says, I don't want everything to go to our son if I die, but I still want help with the bank account because I'm getting old and I want someone to help me. And in this scenario, he has the same type of will as he had before. This says everything to be split between my two kids, because that's really his intent. He wants help with his bank account, but he wants everything split between the two kids when he dies. So what happens in this scenario? My husband passes away. Because he has tenants in common on this bank account, only his interest in it, which is only half, flows down to his estate and then flows down through his will to our son and daughter. So that means our son retains his 1/2 interest plus a 1/4 interest from the will. He ends up with 3/4 of the account while our daughter ends up with 1/4 of it. Now, you may be asking yourself, what if dad owned that account entirely by himself and then put son on? Does that mean anything at all? Nope. Once he puts son on, son has a half ownership interest in that account. And so even though it may have been dad's account at the beginning, he now has essentially kind of gifted half to the son, and has created a situation that upon his passing, son's going to get 3/4 and daughter only gets 1/4. So let's move past that for a little bit. I think you're starting to probably see the risks in terms of estate planning of putting a co-owner on your account, but there are other risks too for when you are alive. So let's say my husband, again, having seen this presentation, said, well, I'm going to be really smart about this. I'm going to put both kids on the account with right of survivorship. So when I die, they can both split the account, problem solved. They can help me as I'm aging. And I've got 2 kids who are helping me, not just one. This is perfect. This is what I'm going to do. Well, what's the risk? The risk is now, while dad is still alive, what he has done by making them co-owners on the account is he has given them an ownership interest in the account. What does that mean? Well, let's say Thomas falls on hard times. Maybe he's laid off. He loses a job. That means Thomas can go in and take money from that account and use it because he is now a co-owner, right? He has access to that account. Or let's say Thomas unfortunately ends up in a bad state in his life with maybe some sort of money problem, right? Maybe some sort of substance abuse or gambling. And so he, again, could get into that account and use that money as he needs. But let's say Thomas he's an upstanding man, right? He's a good young man and he has a good job, no issues with money. But let's say one day he's in a bad car accident and he ends up with a judgment against him from the other side. Maybe someone is very injured in this car accident that's not him, and he's been sued and he has to pay back this judgment. Those judgment creditors can actually come after dad's bank account and start to seize those assets. So what happens by putting the children on as co-owners while dad is still alive, he puts those funds at risk. He is now tying not just his life, but his kids' life to money he may really need to live off of for the remainder of his life. Right? So my husband may really be thinking, okay, I have this bank account and I've got enough money in here to make me to keep me comfortable until age 95. But all of a sudden, because of something that happens in one of the kids' lives, he is unable to, or that money gets brought down and then he is unable to support himself. I also would like to point out that it's the same result, whether or not they are joint with right of survivorship or tenants in common. Now, it's a lesser amount of the money if they're tenants in common that would be subject to the whims of the children, but it still starts to put all of those assets at risk while dad is still alive. Let's play through another scenario that could put dad at risk. Let's say our son finds that lovely woman of his life that he wants to spend the rest of his life with. There she is on the screen, our future daughter-in-law there. And let's say, unfortunately, something happens to our son before anything happens to my husband or to our daughter. What ends up happening, if he is a tenant in common owner, his interest, 1/3 of it, can pass to the wife. Now, if they were joint tenants with right of survivorship, his interest would pass to our daughter or to my husband. But if they are tenants in common, is 1/3 interest can actually pass down to the wife. So, and you can see this play out in different scenarios. Businesses, right? So sometimes you see a mom or a dad put a child on a business, like maybe a hotel or something like that. They do it as tenants in common, and then something happens to the child first, and their interest ends up flowing down to their spouse. That then puts at risk the ability of mom or dad to continue their business. So it can happen in all kinds of ways, not just bank accounts, right? It can happen with land and property. So something you need to be aware of when you start making your kids co-owners on your assets. Frankly, if you are going to put kids as co-owners on your assets, you really want to be sure that those are not assets that you need to live on or think you're going to need to live on as you age. So what's a better scenario here, right? So dad still needs help with finances as he ages, but making the kids co-owners really is not the best idea. So there's my husband and daughter, now much older. What can he do to have some help and support? Powers of attorney are a great thing. So durable powers of attorney that give one of the kids the authority to actually financially handle matters for you is something that works well and is much better than co-ownership. But actually even better than powers of attorney is setting up a trust that deals with what happens if you are incapacitated or just no longer wanting to manage your affairs. Frankly, trusts are probably one of the better but overlooked ways of planning for aging. So we'll talk about that more in our next series in January, the use of the use of powers of attorney and trusts for aging. But I just want to point that out here, that there is an option beyond co-ownership. So let's move on to the second thing, which would be beneficiary designations. So let's talk about what is a pay on death beneficiary, and let's talk about what sorts of assets typically have pay on death beneficiaries associated with them. So first of all, what is a pay on death beneficiary? So your structure, you can already see, looks different than co-ownership. So you would have a situation where you have an owner, in this example, me, and then I would designate someone as a pay on death beneficiary, it's a POD, of my account. So in this case, let's use just a simple bank account. Let's say I'm the owner, and I say, once I die, I want all the funds to go to Bob. Bob, my husband, can't necessarily get to those funds while he's alive because he's not an owner. But once I pass, I'm ensuring that those funds go directly to him without the need for probate. So that's typically why people like pay on death beneficiaries. They are incredibly efficient once someone has passed to get assets to someone. So again, here, let's say I passed, then everything would go down to my husband. Just realize that while in this scenario I'm showing you here, there's only one owner, me, you can actually set up this scenario with multiple owners, and you can use it in conjunction with right of survivorship. So let's say you and your husband had a bank account that you were both joint right of survivorship on. You could then also add a pay on death beneficiary to that bank account that says after the second of you to die, you want that money to go to X person. So again, highly efficient at transferring assets. You do have to be careful on pay on death beneficiaries that whoever you're pointing it to is not a minor or incapacitated or on means-based government assistance. So those can all create problems if you try to directly give by beneficiary designation assets to people who shouldn't really be managing them for one reason or another. You can kick off some guardianship issues there. So just be aware of that. They're great and they help avoid probate, but you want to be careful who exactly you're pointing it to. So what sort of assets typically have pay on death beneficiaries associated with them? These are usually retirement plans, as one example. And you'll remember earlier on, I said that retirement plans are a little bit different from your investment accounts and your bank accounts. When I use the term retirement plans here, again, I'm talking SEPs, 401ks, IRAs that typically only have one owner. So you will often see a beneficiary designation associated with those. You often see them associated with the insurance policies. All right, so you will own a policy on someone's life, and if someone dies, then there is a pay on death beneficiary associated with that. You can see them with bank and investment accounts. And just like with the right or the ownership with right or survivorship, you can actually name a beneficiary for your motor vehicle. So this can be really helpful if you are single and you maybe don't have a whole lot of assets and you want to just very quickly and easily leave your car to someone. You can use this beneficiary designation. You can also use it for other things as well. Sometimes you might want to put it somewhere else for some other reason. So helpful. So this brings us to the question that we asked with the ownership and the rights of survivorship. Who wins if your will is different than your beneficiary? And in this case, just like with ownership, your beneficiary designation wins. So you have to be careful how your beneficiaries are appointed and make sure that those are mirroring or reflecting exactly how you want your estate to go. So let's do this again. Let's run through another scenario. Let's say I have a retirement plan that I have named my husband the sole beneficiary of. But let's say I have a will and I have left everything to my kids. And really my intent is that retirement plan goes to the kids because they may, let's say I think they're going to need some money for college or to maybe start their lives, buy a house, have a wedding. Well, if I die and if my beneficiary designation is still my husband, he's going to get that 100%. So with retirement plans may not have been the best example to use here because there are some other considerations under federal law concerning spouses and because of community property in particular regarding retirement plans. But I think you get the general idea of if you use a pay on death beneficiary, it's going to go to whoever you point that to, not necessarily who you have in your will. So why would you use these? Why would you use joint right or survivorship or a beneficiary designation? A long story short, you'd use them for convenience to avoid probate. So I've mentioned this a couple of times already, that these, by leaving something with rights of survivorship or a beneficiary designation, you actually can avoid probate. So that means that those assets to pass on to whoever you've named, they simply have to fill out the paperwork for whichever institution is holding that asset, give them a death certificate, and they turn over that asset to whoever the beneficiary or the joint ownership is. So it makes it really simple on whoever is left to gather up assets. They don't have to go to court and ask for court to approve a will and then take that will and letters testamentary and do all the publications and everything else that come with a probate. And again, we'll talk about what probate is and what all involves in our last session, but a lot of people find benefit in being able to avoid it. Now, more often than not, what I see with estate plans is they are a mix. They're a mix of a will with beneficiary with rights of survivorship. And so that's why it's important when you're doing your estate plan that you are looking at all of these assets and you're figuring out how they are titled and if there are any beneficiaries associated with them to make sure that they are going with your overarching plan and your will. So if your concept is you want everything divided amongst your kids, everything's going to actually get divided equally amongst your kids. So some final thoughts on this here before we wrap up. One, don't assume. Do not assume that just because you both are on the deed or the bank account that you are right of survivorship or tenants in common. As I mentioned earlier, different states have different ways of doing things, and frankly, different banks. It is all very dependent on what human being helps set up that asset for you. So a lot of times you will see financial advisors, bank tellers, insurance salesmen. They'll make a suggestion to you based upon how their clients typically point beneficiary designations or how they typically have ownership set up. And that may or may not flow with what you want for your estate plan. So don't ever assume that you are set up one way or another. You need to look back at the documents. And I know lots of people say, oh my goodness, I don't even know what those documents are. You can get copies of your bank agreements from the banks. You can get copies of deeds from the public records. It's actually pretty easy to pull up this information if you don't know where yours are at, or if yours are in a box in the attic and you really don't want to go up there and get them, you can find them. And when you're going through estate planning, that's a good time to make sure you've got all those documents together and you know exactly what is in them. We've mentioned this a couple times today as well. Different states have different laws. So for example, Texas is community property. Because of that, most real property, such as land and houses, is held as tenants in common. But somewhere like Colorado, if you have a spouse who you own a piece of property with, lots of times it's held in joint tenancy with right of survivorship. So don't ever assume that two states are the same or that one state is going to handle it the same as your previous state did, because they may not. And again, as I mentioned at the very beginning, there's always in Texas this kind of overlay of community property, which complicates things as well. And then last is you need to review this stuff periodically. There are lots of things that will change in your life. So for example, while those are recent pictures of me and my husband, my kids are much older than in that picture, although I love that picture because it's very cute. And so what we set up when they were that age may not be what we want set up at the age they are now, or what we want set up once they're adults. You have to keep looking back at these things. One of the other things I see quite often is people who start their career before they're married, and maybe they start at that point 401k plan, or they get some life insurance, and they don't know really who to name the beneficiary because they don't have a spouse or kids that they're trying to plan for or protect. So they'll name maybe a sister or a brother or a parent. And then all of a sudden it's 30 years later, they have a couple of kids who are almost grown and their parents are long gone and they haven't changed that beneficiary designation. So you really need to check on these. Another time that you want to check on them is after divorce. So in Texas, there are some laws that will affect, if you are divorced, your beneficiary designation. So sometimes when people divorce, they still want those assets pointed towards the ex-spouse for whatever reason. Well, if they don't restate that afterwards, that may be complicated under Texas law because of the divorce. So as your life changes, so should these things. And so beneficiary designations are easy to change. Ownership designations are harder. So again, if you put your kids on and then you want to change that ownership designation, you're going to have to get your kids' agreement to change it. So you also, with ownership in particular, you want to be very careful who you put on as an owner with you. So yeah, so there's a picture of everyone being much older, thus the example of you really need to make sure as you go along, you're keeping this all updated and is all flowing with your estate plan. So thank you so much for sharing your time with me today. I am going to turn off the recording here in just a second so I can take some questions and answers. Again, this is for educational purposes. I hope that I've been able to give you some information that is helpful, and thank you for joining me.